Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Well, good morning to all. I am Chief Justice Tom Parker, and on behalf of all my colleagues here on the Supreme Court, I welcome you here this morning for this special oral argument session. As you may know, most of our oral arguments occur in Montgomery, in the beautiful Heflin-Torbert building, which some of the students may have visited in the fourth grade. But every year we try to get out on the road at least once or twice to take our docket around the state as an educational experience. Earlier this year, we were in Tuscaloosa. Last year at this time, for Constitution Day, we were at the Lurleen B. Wallace Community College in Andalusia. And today we are delighted to be back here in Mobile again, especially on this beautiful campus. In my brief remarks today, I want to thank those who've helped make this event possible, to introduce the members of our court, and to mark the importance of Constitution Day and the incredible founding document that we are blessed to still celebrate. There are many people here to thank for their welcome and hard work in putting together the events of today. First and foremost, we wish to welcome all the students who are here in attendance. We hope this session will be educational and informative and even inspirational for you as we show the judicial branch of Alabama in action. Now, this is what we are dedicated to provide equal justice for all citizens of our great state. And for those of you who may go on to law school, one day you may find yourself arguing before this court, so pay close attention to what transpires today. And we also want to thank your professors for giving you leave from class to be with us today. To the leadership of the University of South Alabama, we thank you for your gracious hospitality, both last night and today, and for all the work you have put into making this a successful visit already for us. And we particularly want to thank President Joe Bonner, Circuit Judge and USA Trustee Mike Wyndham, and the Mobile Bar President Forrest Latta, who spoke to you earlier. Thank you also to Provost Andy Kent, as well as Nick Lawkis and Anna Catherine Fincher from the Government Relations here at USA. And we also wish to honor and thank Chief of Police Philip Fischel and his team of officers for protecting us and making sure we got to the right place at the right time. It's been a very professional reception that we've had. We are very amazed at the campus and at what you have done for us, and we just thank you for that. I see President Bonner right in front of me, and President Bonner, we thank you. So I want to introduce my justices on the court now. So to my immediate right is Justice Greg Shaw of Daviston. To my left is Justice Kelly Wise of Prattville, and we're sitting in order of seniority, so that's why we go through the announcements this way. To Justice Shaw's right is Justice Tommy Elias Bryan of Brantley. To Justice Wise's left is Justice Will Sellers of Montgomery. To Justice Bryan's right is Justice Brad Mendham of Dothan. To Justice Sellers' left is Justice Sarah Stewart of Mobile, who spoke to you earlier. To Justice Bryan's right is Justice Jay Mitchell from Birmingham, our Homewood. And to Justice Stewart's left is our newest justice, Justice Greg Cook of Vestavia Hills. And as I mentioned earlier, I'm Chief Justice Tom Parker from Montgomery. I'm also glad to recognize the clerk of our court, Megan Rodebeck, and her staff we have here with her is Chelsea McLaurin. I don't see Chelsea in right here. Oh, she's been helping us throughout this process. And we want to thank our hardworking IT personnel who are here, Preston Lane and Robbie Headley. And last but not least, we wish to thank the marshal of our appellate courts, Earl Marsh Jr., and his team of Chief Deputy Marshal Chris Martin and Deputy Marshal John Sutherland for their work in helping this come together today and protecting us through the process. And so let me make a few brief remarks about Constitution Day, which occurred 2 days ago on September 17th. That commemorated the date in 1787 when, after a long, hot summer in Philadelphia, the delegates to the Constitutional Convention signed the United States Constitution and recommended it to the states. Many of these founding fathers had fought for independence from Great Britain a decade earlier. Some were drafters of our Declaration of Independence of 1776, and others were members of the Continental Congress, which sought to control things in this country until a permanent government could be organized. And from that declaration, I want to quote the philosophy of America, that all men are created equal and endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. The Constitution was built upon the Declaration principles of ordered liberty, equality of law, and the rule of law, not the rule of men or of monarchs. As the delegates signed the Constitution within Independence Hall, Americans waited expectantly to see for themselves what they had. And when Benjamin Franklin left Independence Hall, left that ceremony for signing, he was asked by a lady outside who was waiting, "Well, doctor, what have we got, a republic or a monarchy?" "A republic," replied Dr. Franklin, "if you can keep it." As the Constitution circulated throughout the young United States, men and women throughout the country of all walks of life, lawyers, clergy, merchants, students, farmers, and blacksmiths, read, studied, and debated its details among themselves. Those details included the separation of powers divided among the Congress, the President, and the judicial branch, the few limitations that were placed on state governments, the process of amending the Constitution, and the provision that declared that the Constitution is the supreme law of the land. The Constitution was not a long, arduous document, nor was it full of flowery and ceremonial prose. It was and is short, clear, direct, and sometimes boringly technical. The Constitution was not written just for judges and lawyers, and it begins by clearly noting who it is for: we the people of the United States. It was ratified by the people themselves acting through the several states. It established a constitutional republic and a federal form of government that gave the national government certain limited powers and reserved the rest of those powers to the states and to the people. The preamble of the Constitution expresses why we the people ratified it. It says, "We the people of the United States, in order to form a more perfect union, to establish justice, to ensure domestic tranquility, to provide for the common defense, to promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." This Constitution still encourages us to establish justice and to secure the blessings of liberty for all. And the amendments that the people added to it, the Bill of Rights and the 17 other amendments, sought to further protect individual rights, enforce equality and liberty, and work toward the ideal of a more perfect union. Our Constitution depends not just on judges, legislators, presidents, and lawyers. Our Constitution endures because we the people, that means you the people, read it, study it, cherish it, and if you take an oath to it, to defend and support it. Lastly, I want to remind you that the United States Constitution signed in 1787 was not the first Constitution in America. All 13 states, from New Hampshire to Georgia, had their own constitutions. And many of the features of the government and the individual rights that we hold dear were in those original state constitutions. They provided the source material for the drafters of the U.S. Constitution and the later Bill of Rights, some portions of which were directly copied from the state constitutions. You see, the U.S. Constitution did not appear out of thin air in Philadelphia over that summer. Rather, those delegates that gathered brought from the 13 states and from the English common law all the principles that we hold dear in our federal Constitution today. Separation of powers, free speech, freedom of religion, the right to bear arms, the right to trial by jury, and even the very idea of a Bill of Rights. Why do I mention the state constitutions? Because not only did the state constitutions of the 1770s and the 1780s inform the crafting of the U.S. Constitution and help us to understand what the founders meant when they wrote the U.S. Constitution, but all 50 state constitutions today still operate to govern state government. It's governors, legislators, judges, mayors, law enforcement, etc., and to protect individual rights, often in a greater and more specific way than even the U.S. Constitution. Not surprisingly, every state official, attorney, and judge in this building today has taken an oath to uphold the U.S. Constitution, but also the Alabama Constitution, and we take both oaths seriously. I encourage you to pay attention to the Alabama Constitution too, the first one being ratified in 1819, close to the founding era of this country. And today, even our current Constitution, which was ratified in 1901 and ratified again in 2022. It's been amended rather frequently and regularly. Here in Alabama, we excel at football and amending our Constitution. Our Alabama Constitution may not be as short of a read as the U.S. Constitution, but it is probably even more important in the everyday lives of everyone in this state, including the high school and college students of Mobile. If you are of voting age in our audience today, then you have the direct power to amend the Constitution at the ballot box. As Chief Justice, I take seriously the Alabama Constitution preamble, which is very similar to the U.S. Constitution in that it seeks to make the establishment of justice the first priority of state government. But our Alabama Constitution preamble makes an important addition when it states, invoking the favor and guidance of Almighty God. Every state constitution has a similar invocation of divine providence. And as we turn to the particular arguments in the case before us this day, and as you leave after the oral arguments to return to your schools and homes, please do not forget my charge to you. On this recognition of Constitution Day, keep the U.S. Constitution and the Alabama Constitution as your own. I know they seem dusty and old, and in parts hard to understand, but please do not forsake them as something for only judges, lawyers, and politicians. How do we keep the republic as suggested by Benjamin Franklin? By remaining a nation under God and under law. Do not be content to know some things about the Constitution. Do not be content to hear officials talking about its importance and what it means. read it, study it, defend it, because the future of this state and this country depends on you, the people, you, the students, doing just that. So today we commemorate the September 17th Constitution Day with this public oral argument, and I want to now ask our clerk of the court to call the docket for us.
In case number SC 2022-0515, James LePage and Emily LePage as parents and next friend of two deceased LePage embryos, embryo A and embryo B. William Tripp Fondy and Caroline Fondy as parents and next friend of two deceased Fondy embryos, embryo C and embryo D. The Mobile Infirmary Association, doing business as Mobile Infirmary Medical Center and the Center for Reproductive Medicine, PC. And in case number SC 2022-0579, Felicia Burdick Isan and Scott Isan in their individual capacities as parents and next friend of baby Isan, deceased embryo, with the Center for Reproductive Medicine, PC, and Mobile Infirmary Association, doing business as Mobile Infirmary Medical Center. Arguing for the appellants, the Honorable David Wardis and the Honorable Tripp Smalley. And arguing for the appellees, the Honorable Christian Hines, the Honorable Austin Mulheron, and the Honorable Tommy Keene.
And just a word to the audience before we get started. We have two cases consolidated for this oral argument. That's why you have so many attorneys here, and they will be dividing their time. There are lights on the rostrum that will indicate their time limits, and with the help of our clerk, we'll make sure that we're able to marshal this accordingly. So, Mr. Wardis, you may begin.
Chief Justice Parker, Associate Justices, good morning, and if it please the court. Plaintiffs appear before the court this morning seeking reversal of an order from the Mobile Circuit Court dismissing plaintiff's complaint as amended, and ostensibly the dismissal order was entered under Rules 12b1 for want of standing and 12b6 for failure to state a claim. Because we're before the court on a dismissal order, the court's review is limited and constrained. The standard of review is de novo. The dismissal order has no presumption of correctness. And the record, because again it's a dismissal, is a very limited record. 367 pages in the clerk's record, 94 pages in the transcript from the hearing on the motion to dismiss. So you have a very limited body of materials to work with, and you won't be hearing us arguing today about the political repercussions, philosophical implications of when life begins, public policy arguments about what the consequences of this court's judgment might be. Those would be wholly inappropriate for a party on a motion to dismiss under this standard of review to try to persuade this court with. The remedy, of course, is after the court does what the law requires the court to do under our settled law, if there's some disagreement, parties can approach the legislature and try and make a change from whatever the court's judgment is. But today, we're here advocating on behalf of the plaintiffs who are supporters of in vitro fertilization. It worked for them. They have two beautiful children in each family because of in vitro fertilization. The notion that they would do anything to hinder or impair the right or access to IVF therapy is flat wrong. That's not why we're here. What we're advocating is, if you're in the business of helping create embryonic children, you better also be in the business of safeguarding them and protecting them. locking the doors. When you go to the infirmary and you see babies in the maternity ward, you see them with grandma and grandpa and the children waving, they're behind a locked door and protected glass. Same should happen with unborn embryonic children. Now, how do we begin? The first issue for the court is whether the word child in 65391, the Wrongful Death Act, encompasses unborn embryonic children. And for the benefit of the audience, the court doesn't need to hear this, but the wrongful death statute reads as follows. When the death of a minor child is caused by the wrongful act, omission, or negligence of any person or persons, corporation, or their servants or agents of either, the father or mother, or if the father and mother are both dead, or if they decline to commence the action or fail to do so within 6 months of the death of the minor, the personal representative of the minor may commence an action. So what does the word child in 65391 mean? And how do we help the court construe that word to encompass or bring within its scope unborn embryonic children? We believe the starting point is where the citizens in 2018 amended our Constitution and its Declaration of Rights by what is now found at section 36.06. And again, for the benefit of the audience, as part of the Declaration of Rights, we exempt from the operation of government the rights voted on by the people. And the language in the preamble to 3606 reads as follows. To guard against any encroachments on the rights herein retained, we declare that everything in this Declaration of Rights is accepted out of the general powers of government and shall forever remain inviolate. So what did the people decide? In subsection A, this is now the law in our Declaration of Rights. This state acknowledges, declares, and affirms that it is the public policy of this state to recognize and support the sanctity of unborn life and the rights of unborn children, including the right to life. In subsection B, the state further acknowledges, declares, and affirms that it is the public policy of this state to ensure the protection of the rights of the unborn child in all manners and measures, lawful and appropriate. So when the people voted and chose to use the words unborn children and unborn child, how do we inform whether that goes so far as to apply to 65391 and the legislature's use of the word child in that statute?
Not to stop you, but the wrongful death statute here was passed in 1872, right?
A version of it, yes, sir.
Yeah, and it's not been amended. The verb minor child, that language has not been changed since 1872, right?
Correct.
And before the Brody Act, the one that amended the Homicide Act, before that act, we as a court had repeatedly ruled that an unborn child in the fetus was not a minor child under the Wrongful Death Act, correct?
Well, until 2011 when that changed in Mack v. Carmack.
Right, because of the Brody Act.
Not just because of the Brody Act. No,
Help me why that was not just because of the Brody Act.
No, well, the Hamilton decision, to expand on your definition, says the Wrongful Death Act applies to any unborn child, not just fetuses, and certainly not just in utero children. It's very curious in the order of dismissal. The circuit judge writes, this court visited this issue on 2 occasions, and it cites Mack v. Carmack, and it cites Stinnett, but it doesn't cite Hamilton. And why? Because the order prepared by our friends representing the defendants can't defend or fight against Hamilton. Hamilton explicitly states any unborn child, and that's why I'm building.
But that's kind of circular, though. I mean, that doesn't answer the question of what a child is, right?
Well, that's why I'm in the process of talking about what was before the citizens when we voted in 2018.
But they didn't amend the constitutional change in 2018 didn't amend the statute from 1872, right?
Did not amend the statute. That was not put to the citizens for a vote. But, Justice Cook, at that time, there were a number of statutes that were part of the warp and woof of what the citizens voted on and could have understood the word unborn child and unborn children to mean at the time they voted. And so you must pay deference to what the legislature defined, and I'll give you a list of 5 statutes. Let's start with the chemical endangerment statute. 2615 3.2a, child. This court construed the word child in Ex parte Ancrum, a 2013 opinion, to mean unborn children, and extended the reach of this criminal statute with a higher burden of proof than a civil wrongful death statute to unborn children. It did so by reference to dictionary definitions.
Mm-hmm.
The Abortion of Viable Unborn Child Act from 1997, which is now codified at section 2622.1 and 2622.2. The legislature defines unborn child and fetus as an individual organism of the species Homo sapiens from fertilization until live birth. So the citizens, as of the vote in 2018, knew just from that one statute, and there are more that I'm about to talk about, that we defined unborn children in our law as from fertilization until live birth.
The abortion statute covers in utero children, though, right? That's the language
By
in the abortion
definition,
statute.
Of course. Can't have abortion unless there's gestation and pregnancy. But it's a related statute. It defines children, unborn children.
And
So-
I'm sorry, go ahead. I apologize.
Under the Woman's Right to Know Act from 2002, now codified at 2623A 310. Unborn child is defined as the offspring of any human person from conception until birth. Again, that was before the citizens at the time of adoption of 3606. The Brody Act that Your Honor referred to, that was a 2006 amendment to the criminal statute defining what constitutes homicide. And it defined, as we say in the briefs, I want to get the language just right, the term, when referring to the victim of a criminal homicide or assault, means a human being, including an unborn child in utero, at any stage of development, regardless of viability. And we'll come back to the rule of construction about the use of the word including in legislation.
Yes.
Mr. Ortiz, your red light is on, but because this case has so many issues, go ahead and finish your list that you are proposing in response to this question. And Madam Clerk, let's make sure that we give a comparable amount of time to the other side.
Thank you, Chief Justice. The last statute I wanted to mention in this part of the argument is the Alabama Human Life Protection Act. Of course, it was promulgated in 2019, a year after the constitutional vote, but it borrowed the language from the Brody Act and now reads, unborn child, child, or person, a human being, specifically including an unborn child in utero, at any stage of development, regardless of viability. So we had these statutes in law at the time the citizens voted to accept from government the enshrined protections of all Alabama law for unborn children. We have more to talk about. I know my time is up temporarily. We'll talk about this court's decisions that had been rendered before the 2018 vote as well. Thank you.
Thank you, Mr. Ortiz. Mr. Smalley, you are next.
Good morning, Mr. Chief Justice, Associate Justices. I want to talk more specifically about the trial court's order, because Justice Cook, you mentioned circularity. And the circularity in this case is a defendant's argument that these embryos can be both human beings on the one hand, but not be minor children on the other. And that's what when we got this trial court's order, we read it and we read it and we couldn't make sense of it. And finally what came to us is that it's got this catch-22, where these embryos are the only things that are living that aren't protected under some aspect of Alabama law. My family owns a cattle farm up in Gadsden. We grow cattle, we grow corn, we grow timber. My grandfather loved that farm so much he's buried on it. Under Alabama law, if you come and you kill my cattle, if you take down my corn, if you wrongfully cut my timber, if you go and you denigrate my grandfather's grave, I have a claim. I have a claim for all of those things. But under the trial court's order, under the defendant's argument, these IVF embryos that are human lives, that are no different than any other embryos in the world other than their location, would have complete civil immunity. There would be no claim under Alabama's tort laws for the wrongful death or destruction of these embryos. And that word wrongful is key to understanding this case. As Mr. Ward has talked about in his opening, this is one of the most blatant, glaring acts of negligent security that I have ever seen. They didn't lock their doors. They didn't do the most basic of things that were asked of them in this case. And to allow that type of wrongful act to lead to a situation where there are no civil remedies just cannot be the law of this state.
And I'll have to say, I'm very attracted by your catch-22 argument. I mean, the idea that you cannot have any liability, it means there's going to be no incentive to protect it. Okay. Help me out, though. Like, what's the measure of damages here?
That's an excellent question, Justice Cook. And if we go under the wrongful death claim, then it would be our usual punitive damages that we have in any type of wrongful death action. However, if the court were to rule that there is a line of demarcation such that embryos that are in utero are going to be treated separately than embryos that are in vitro, I would say that we would treat them just like any other claim, and the juries of Alabama certainly can put a value on this. And to your point, this exact issue was tried in California and San Francisco in 2020, and the jury came back and rendered a $15 million verdict for 5 families that went through exactly what our clients did. And I will say this, it's my opinion that if the good folks of San Francisco can do it, the good folks of Mobile County can do it as well. I think.
Well, I'll just say I'm not. I was aware of that case, but I'm not particularly attracted by the California case law. But I am very attracted by the idea that this catch-22 argument. It really bothers me, and I'm going to definitely ask the defendants about it on argument. And I'll have to say that the Raley case that y'all cited, dealing with dismissal at 12B6 stage for lack of damages, is a real problem for me, and I noted that they did not notice that case. But I'm still, tell me what would happen if your cattle was killed. What's the measure of damages?
So the measure of damages in that case is that you would go and you would look at what a cattle is worth, so to say. And I will agree that this would be a difficult case to value, absolutely, to the extent that we want to view this like the Jeter case in Arizona did in the early 90s and say, we're going to call it a special type of property. I absolutely think that's a difficult decision.
And the word property is a problem, I think. It's talismanic. It's a third rail kind of word that I don't think we want to use.
And we 100% agree. The issue that we have is under Alabama law, the way that we separate things is you have 2 items in all of existence. You have human lives and you have everything else.
Yeah.
So what we are faced with is this decision, are we going to have this be considered a human life or something else? And the manner by which we title it, I don't think is necessarily as important as reversing the trial court's decision that there are no tort remedies. That's the fundamental issue that we have before this court.
So I hate to interrupt you, but your time's limited. What your argument is, there's no remedy whatsoever under Alabama tort law for these embryos or for these parents. I mean, it's wrongful death. That may be the issue here, but is there something less than wrongful death that the families could recover under?
And to your point, Justice Sellers, when we filed our First Amendment complaint, we specifically said, look, to the extent that the Wrongful Death Act doesn't apply, we have a negligence and wantoness claim. And the defendants implicitly conceded that point at the trial court on the ISAN case because their motion to dismiss was titled Motion to Dismiss Certain Claims. They didn't seek to dismiss the negligence claim. They didn't seek to dismiss the wantonness claim. All that they sought to dismiss was the wrongful death claim. And so, to your point, I do think that we would have a negligence or wantonness claim. We would just, the way that we titled, I certainly think to Justice Cook's point, we would need to be respectful of this. It's a difficult issue to just call these embryos property. I don't think that's correct.
But
Yes, ma'am.
is it the job of the judiciary to determine what the value of life is, or is that a legislative issue?
That's a great, the question becomes, to the extent the legislature has to some extent left this to the court's decision as to how we're going to define this particular area of life. And what Alabama law has developed over the years is in many ways the science has surpassed the law. And it's time that the law catches up to that. And other states have come up with a remedy. We just certainly can't be the only state by which there is no remedy at all. And so whether it be under our wrongful death statute, which I think Mr. Wirtis has eloquently stated, we think that's the proper remedy. We don't think there's any reason to separate in vitro embryos from in utero embryos. But to the extent we think that having our usual property remedies, providing the jury with some measure of damages to the extent we would look at what's the value to the plaintiffs. That's how we normally value property, to your point, Justice Cook. And I think that there would be a remedy here.
Have there been other jurisdictions similar to Alabama's Wrongful Death Act that's covered frozen embryos before?
Not under a specific wrongful death statutory scheme, but Justice Brown, the issue when you look at other states, the problem you have is, and this is something that Mr. Wirtis talked about in his briefing, when you do a survey of this, you have to have such an understanding of each individual state's viability requirements in the wrongful death case. And I'll give you just a quick example. I know my time is up.
No, you're good.
Okay, like in Ohio, for example, they have a viability requirement. So would this case overrule that requirement? Would this court overrule that requirement in Mack? Ohio didn't. Other states haven't as well. And so when you look at those other states, to Justice Cook's point about California not being maybe the leader here when it comes to how we're going to claim it, I'm just looking at them as to saying they can have a remedy, we can too. I do think that it's difficult just to look at other states because we are one of the few states that has a constitutional provision that says we're going to protect all right to life from the unborn. We're going to make that a key aspect of our fundamental beliefs. It's in our statutory scheme. It's been a big part of this court's decision-making really since Mack in 2011 on, which overruled those cases from the early 1990s that I really think fundamentally got it wrong. And so it's hard to look at other states and see how they've done it, but Arizona, New York, New Jersey, Rhode Island, California, just to name a few off the top of my head, do have some type of judicially created remedy, which is the fundamental question we're asking. Is this let our folks have their day in court, whether it be under a wrongful death claim or some other claim that we judicially create? We've been doing that for literally hundreds of years. It's the bedrock of our common law system.
But we don't have the power under, if it's a statute, I can't decide, well, the public policy should be this. The statute is what the statute is. But if it's a common law claim, I think we have a lot more leeway to say, well, okay, we'll look at the public policy in making that determination. I just struggle with what that measure of damages is. Maybe that's for the summary judgment stage instead of the 12v6 stage. I don't know.
It could be, and when I talked to the folks in California, one of the things they talked about is this idea that it's unique, that it only exists a single solitary time in the universe. But they also talked about that was a troublesome aspect, but they thought the jury got it right. I mean, the jury awarded a very large verdict for 5 people. Fundamentally, what we're talking about was something that can never be replaced. It was taken from them from the wrongful acts of someone else. And I really think that our juries, I know, Justice Stewart, you were on the bench for several years, and many of y'all were as well. Juries have a weird way of getting it right. And I would really trust that they could fundamentally come up with some valuation, whether it be under a mental anguish scheme, under some type of
we got to decide who this belongs to as well. I mean, whether or not you're bringing the claim on behalf of the parents as next friends for the infant, for the embryos, or whether you're bringing it on their behalf themselves. Your complaint brought it on both behalves, is that right?
Yes, sir. So we brought it as a wrongful death claim under 65391 as the parents, And we also brought it in their individual capacities to the extent the embryos were not considered human lives.
Are both cases brought that way?
Yes, sir. Well, thank you for your time.
Mr. Smalley, thank you. And before we start with the other side, Madam Clerk, this ran quite a bit over. And so, counsel, there are three of you that are going to argue. Who does the extra time go to? Everybody's pointing to one. Okay, so we've got the roadmap ahead of us then. Please, Mr. Hines.
May it please. It is. Everything's off. I'm on airplane mode, justice-wise. I've double-checked everything. And may it please the court, and welcome Mobile, and Justice Stewart, in your case, welcome home. I'm Christian Hines for the Mobile Infirmary. For the purpose of this oral argument, we thought it might assist the court if we sort of divided the argument somewhat. So I'll be addressing all the wrongful death issues, and that's why I would have the extra time. And Mr. Austin Mulheron for the Center of Reproductive Medicine will be addressing the alternate claims, the tort claims, and negligence claims, et cetera. And then finally, Mr. Tommy Keene will be arguing for the Amicus, the Medical Association of the State of Alabama.
Mr. Hines, before you get started,
Yes, sir.
let me lay just a couple of things down as a foundation for you to think about as you proceed.
Yes, sir.
You know, normally the doctrine of separation of powers precludes us from rewriting statutes. We don't make public policy in Alabama. That's the job of the legislature. At times we have to try to discover what that policy may be when we have an ambiguity in a statute, and the doctrine of separation of powers allows us then to step in and try to figure out what the legislature was trying to accomplish. Normally when we do that, we try to identify that ambiguity, and sometimes it's patent, sometimes it's latent. Patent meaning we've got an inconsistency on the face of the statute, latent meaning we may have an inconsistency generated from other statutes or something else. At that point, you know, we would then engage, if it is ambiguous, we would engage in construction. And until that point, our authority basically is to apply the statute as it is clearly written. We only know what the legislature intends by what the legislature says. So with that framework in place, and the fact that this court has, in at least two cases, looked to the Homicide Act to inform us as to what the definition of minor child is in the Wrongful Death Act. I wondered if at some point during your argument, if you can go specifically to the language in that Homicide Act and tell us what did the legislature do when it put that new definition in that Homicide Act, and how does that inform us as to what the Wrongful Death Act should mean?
Yes, sir. Well, then I will start there, Justice Shaw, because I think if we remember what the debate was through the years, is the line of demarcation. Is it birth? Is it viability? Is it pre-viability? And so I think with the legislature, what they're doing when they say they amended the Brody Act to say a human being, including an unborn child in utero at any stage of development regardless of viability, they're trying to settle that argument, settle the fact that we were talking about in utero. All in utero was protected regardless of any viability, regardless of any development or any stage. So I think that was the intent of settling that question with the Brody Act.
Mr. Hines, I want to follow up with another aspect of what Justice Shaw asked you about. In your brief, you raised a claim that the plaintiffs did not make a statutory construction argument before the trial court that they're making in their brief. You're not trying to say that this court is limited in its role of statutory interpretation to only the statutory rules of construction that are argued by the parties.
Well, Chief Justice Parker, what I am saying is this sort of black letter that if an issue is not presented to the trial court, then it cannot be raised for the first time and on appeal. And what I mean by that,
Well, that would not limit this court from using standard statutory rules of construction, would it?
well, I think if I could go back, and then I'll answer your question directly, Chief Justice, I promise. At the trial court level, the plaintiff appellants made a concession that the Homicide Act and the Human Life Protection Act only protects in utero embryos. And I'm referring to the record on appeal at 204, the reply B for the Fondes and Lepages to our motion to dismiss. They made this sentence: defendants cite to the Alabama criminal homicide statute and the Alabama Human Protection Act, the anti-abortion law, for the proposition that a child must be in utero for a wrongdoer to face criminal prosecution for homicide. And at the trial court level, they followed this sentence by "this is true." Now, on appeal, they cite that sentence almost verbatim, but they followed up with the sentence, "this may be true." And I think the reason that concession was critical, and then they go on to make this new statutory construction argument. And I think the reason that concession was made and why it was withdrawn, because the Mack and the Stinnett cases that you discussed, Justice Shaw, because Mack stressed, quote, the need for congruence between criminal law and our civil wrongful death statutes. And there should not be different standards in wrongful death and the homicide statute because of their shared given purpose. And then in Stinnett it said, quote, barring the definition of a person from the Brody Homicide Act makes sense to inform us from who is protected under the civil statute. So conceding the Homicide Act and Act's definition of a person at the trial court level was devastating to their argument on appeal because, Chief Justice Parker, you make the statement in Ex parte ZWE when discussing interpreting statutes, we also try to interpret the statute harmoniously with other statutes that address related subjects. And time again, the Alabama legislature and some of the most pro-life legislation passed anywhere in this country has differentiated between embryos inside the uterus and outside the uterus. For example, in the Unborn Infants Dignity of Life Act, this was a statute specifically created with the legislative intent because, quote, the dignity and value of life, especially the lives of children born and unborn, has been and continues to be a public policy and often sacred concern of the highest order of the people of this state. Yet despite that powerful statement of legislative intent, when it came time to defining protections, they defined unborn infant as, quote, a human being in utero at any stage of development regardless of viability. So nothing in there about cryopreserved embryos outside that are not developing outside the uterus, despite that powerful statement of legislative intent.
Mr. Hines,
Yes, sir.
Can you walk me through what that particular act was aimed at? Was this an abortion statute?
It was preserving the dignity of life of children that might be deceased or might be. It was pre the 2019 Abortion Act. But again, it defines who is protected. I guess it's to the point that there should be no difference between inside and outside because they define and treat differently embryos that are outside the uterus when they exclude from the scope of a protection ectopic pregnancy, which is, quote, any pregnancy resulting from a fertilized egg that is implanted outside the uterus.
But that's not a viable pregnancy. An ectopic pregnancy is not viable.
Well, it is a fertilized egg.
It is, but
Just
it's not
like
viable.
an in vitro, well, an in vitro egg is not viable either. We don't even move down the path of viability until we're placed in utero. So I think that's a connection. And the Alabama Human Life Protection Act, the sweeping Alabama anti-abortion statute passed in 2019, it does the same thing. It excludes fertilized eggs outside the uterus. So both of these statutes were passed in the spirit of this 2018 constitutional amendment, recognizing Alabama's support for the sanctity of unborn life and the rights of unborn children.
Can you
Yet
also,
both specifically exclude and treat differently embryos outside the uterus. Yes, Justice Wise.
can you touch on your colleague on the other side mentioned the Hamilton Act? Can you touch on that?
Yes, with all due respect, I'm not following the point on Hamilton. Hamilton was passed after the Brody Act. I mean, it had two issues. One, could a parent recover if they were outside the zone of danger? That's not at issue here. And then they were simply furthering Mack versus Carmack with you can recover for the death of a non-viable fetus. again, the Brody Act amended it to say at any stage of, in utero, at any stage of development, regardless of viability. And that was just, that's Hamilton versus Scott. That's what it says. I think the reason that the order is quotes Mack and Stennett is, again, they're more analogous to the issue before the court, and what they're stressing, what the Mack court stress is the need for congruence between the criminal law and the Alabama civil wrongful death statutes. It also expressed concerns over these sort of bizarre comparative outcomes. If you have one definition for the Criminal Homicide Act, which is what the definition, what the appellant's position was at the trial court, then you could have a bizarre comparative outcome in that application where plaintiffs like the Fondies and Lepages, who have 6 remaining embryos at CRM, they could be prosecuting a civil case for wrongful death against a clinic, and during the pendency of that litigation, they could instruct that same clinic to remove those eggs from cryopreservation with no companion criminal consequences. So we would have this incongruency here in the application of the 2 acts, which this court said should not be happening in Mack versus Carmack because of the same intent and purpose of the 2 statutes.
Mr. Hines, don't
Yes, sir.
some of those statutes make an exception for doctors and medical processes? And that's not what we're dealing with here.
Yes, sir. I think there will never be perfect synchronization between the Criminal Homicide Act and the Civil Wrongful Death Statute, because there is different burdens, and there can be an exception, and that was one of the issues that was carved out in Stennett. There's an exception in the Criminal Homicide Act for doctors and physicians that excluded them from criminal negligence that was held not to apply in the civil. But the key point is the harmonization of that definition of who a person is. The time and time again, this court has said that that there should be harmony between the protections of who is protected under that act, the definition because of the same intent to preserve life. And yes, sir.
Forgive me for having my phone out, but I make a lot of notes on my phone.
Is your ringer off?
My ringer is off.
Equal protection under the law.
Yes, no disparate treatment.
Yeah, I just didn't want you to think that I was not paying attention. I want to go back to the language. There was a lot of argument made in your brief about the modification of the Homicide Act. I think it's the Brody Act,
Yes, sir.
and the language that was added at that point in time, and what effect did that have? I'm looking at before the Brody Act, 13A612 says that the definition of a person, such term when referring to the victim of a criminal homicide means a human being who had been born and was alive at the time of the homicidal act. That was the previous statute. Now, it limits the definition of person to a human being who, quote, has been born. Now, that limitation would indicate that there are other human beings, those not born, to whom the definition of person would not apply. One thing I want to point out there is that human beings there are not defined as those who had been born. Persons was defined as including human beings who have the characteristic of previously being born. So in other words, there may be human beings that may have not been born, and those are excluded from the definition of person, but not from the definition of human being. So I'm getting to my question here in just a minute. After the Brody Act, it says definition of person. The term, when referring to the victim of a criminal homicide or assault, means a human being, comma, including an unborn child in utero at any stage of development, regardless of viability. That, in my opinion, is probably the very heart of what we're being asked to figure out here. If the court is going in this case to do what it has done in previous cases, and that is to look at the Homicide Act to glean or to inform the intent of the legislature as to what the Wrongful Death Act means, we're going to have to understand what did the legislature, what was it trying to do when it says a person means a human being, comma, including an unborn child in utero at any stage of development regardless of viability. We obviously took the viability consideration completely out. We did that in those other cases. So a person is now defined as a human being. So what I'm wondering, I've got some other questions here, but I don't want to get too involved in this. Could you take it from there and tell me, has the legislature given me an example of what a human being is, a non-exclusive example of what a human being is, or has it specifically limited what a human being is in this language?
And I think I'll begin with addressing something Justice Cook.
Can I add
Sure.
also, does this turn on in utero?
I believe it does. And again, despite Alabama's pronouncement on the sanctity of life, et cetera, there were times, like you say, when even the Criminal Homicide Act did not extend to in utero. And it wasn't until the legislature specifically changed that definition that it was extended to in utero. But and it's similar to the question what the court asked in Ex parte ZWE when it said that the task here was not interpreting the word child generally, but what was the legislature's definition of the word child as set forth in the statute? And my point on that is this, again, I mentioned earlier that the debate had been viability. We now have a defined term in utero. If the statutory construct, and what we're dealing with here is the term in vitro. This is a specific, known scientific phrase. It has been around for 5 or 6 decades, since the 1970s. So I don't think it can be the court's new rule of statutory construction that the legislature purposely injects some ambiguity into the statute by leaving out a known scientific unique term like in vitro. It was aware of in vitro, yet it didn't use it. Instead, and the appellants quote the court's rule of statutory construction is this: we will presume the legislature knew the meaning of the words it used when it enacted the statute. And that's precisely our point. The legislature used another unique, scientific, precise term, which was in utero. It was aware of in vitro, yet it never used it. And I think by tracking, again, the legislative history on this issue, there was this issue about viability, and they decided that thing. But
Mr. Hines, I'm going to run Justice Shaw's question here for a minute. I want to focus you back on the phrasing of including, comma including, in the homicide statutes. I have a different view of that. It seems to me that the Brody Act, the legislature was responding to some case law by this court that it didn't agree with in the way that it interpreted the term human being. And so they came along and amended the statute to break out that particular subset of human beings. But it's not your contention that what follows after the word including represents the entire waterfront of an unborn child as it relates to being a human being, right? That would just be a subset of that?
I think the answer to that is in terms of that definition, including is that subset. It's defining, it's trying to settle the question of in utero, regardless of viability. And if the legislature had wanted to extend it outside the womb, because they never have, again, in all the Homicide Act, in the Alabama Human Protection Act, again, they can see that the Homicide Act limits it to in utero.
Mr. Hines,
The
stay
court
close
said
to the
that-
microphone for our recording.
I'm sorry. If the legislature had wanted to extend it to these in vitro embryos outside the womb, they could have used that with two
I think
words.
Justice Mitchell's point is human being comes before the comma. And so his point is including there supposed to be an example of what comes before the comma, which is human being, or is it supposed to be an extension?
I think it's just including, it is within that subset of in utero. Because they could have used in vitro if they wanted to, and this court has said the judiciary will not add that which the legislature chose to admit. You've said it is not the office of the judiciary to insert into a statute that which has been omitted. What the legislature omits, the court cannot supply. And again, this is a known scientific term. And we even quote Senator Clyde Chambliss, and we quote
No, we don't hear that. But what we do hear, tell me why the Brody Act was passed. Does it say so in the act?
It does not say so in the act. I do agree it was a response to this court's ruling about the question about is it viability or no viability. No statute has ever extended protections in Alabama to outside the womb to in vitro. So that was a response to clarify the debate over whether viability comes into play. And again, in utero, we don't even come into the realm of viability until they're placed in utero. These embryos may never, ever get to that point. Many of them don't, if not most of them don't. There has to be an affirmative act that they are placed in a womb. We would never get down a debate on whether it's pre-viable or viable until that embryo is placed in the womb. So we're in a different classification. Again, this is a very specific scientific term that the legislature was aware of and could have used to extend. And again, if this court holds that these are children under the act, then there will be tremendous ramifications for this.
Mr. Hines, let me stop you
Yes,
right
sir.
there. I mean, I think we're very much aware of what the ramifications are here. Y'all did a good job of setting that on your brief. But again, when we talk about ramifications here, I think we need to talk about what the legislature is doing. This is within the realm of legislative action. This court is trying its best to figure out what the legislature is doing here. If the legislature screws something up, that's one thing. But what we're trying to do is figure out what the legislature did. Did I just hear you say that the language including a person is a human being, comma, including, et cetera, non-viable fetuses in Europe. Did I hear you say you thought that was just a subset or an example of a human being that was given protection as a victim of homicide?
No, sir, I think it is just limiting the definition of human being to anything in the realm of in utero. That is our position. Anything with the realm of in utero, because they could have extended it to in vitro because there has been different classifications. Again, even if there's a pronouncement that life begins at conception, the Human Life Protection Act, the abortion statute, excludes even fertilized eggs found outside the womb. They're not within that scope of protection. So there's nothing that is consistent reading harmoniously with the other definitions of other acts where they have differentiated between inside and outside the womb.
Is there a rule of construction that you can refer us to that specifically talks about that? The word, the definition actually says person shall mean human being, comma, including a non-viable fetus in utero. Does the word mean or the words including, is there a rule of construction that would inform us as to what the legislature is trying to do there?
Well, I guess I would go back to the rule of legislation construction that the judiciary will not add that which the legislature chose to admit. And again, being aware of in vitro fertilization since the 1970s, they could have easily extended it to that class of persons. So I think I think we would be going on to a speculative journey to try to go outside the womb when there's been no statute has gone outside the womb, and the lead up to this Brody Amendment, what they're trying to do is resolve that dispute over viability versus pre-viability.
When we're looking at that Brody Act, the Homicide Act, do we have to view that as just a completely brand new standalone definition? Can we look at how it was previously written?
Well,
I figure out what the way it was previously written. I read a while ago. Talking about the having been born and alive at the time.
I just think it informs us that, again, despite a sentiment that life begins at conception. There have been exclusions through the years on various groups within that. And again, our reading of this, is simply it's defining in utero and that lead up to it. So I think the court can look to that and what was preceding it to say this is what they were trying to decide and try to differentiate.
Okay, I have to ask you one more question. I promise
Sure.
I'll leave you alone. Does your interpretation of that language in the Brody Act require us to say that other than, let me word it this way. I'm gonna read you my notes so I don't mess this up. If the definition in the Brody Act is a completely new definition of the word person, replacing the prior definition, then it would appear that human being is undefined, except that it includes an unborn child in utero. Now you're saying that is not correct. You're saying that that language is a specific limitation. Now if we assume that the unborn are not human beings, then the addition of a, quote, an unborn child in utero, close quote, adds only those types of unborn children to the definition of human being. So my question to you is, if we accept your definition, what then would be a human being?
I don't think, and I think Mr. Wurtis even echoed this, we're tasked here with defining when life begins. It's the definition of minor child under the Civil Wrongful Death Statute. And we've outlined how the Human Life Protection Act, even though we have this constitutional amendment and statement in support of the sanctity of life, it excludes fertilized eggs outside the womb. Just like, and I think the Brody Act is consistent with that. The Infants' Dignity of Life Act excludes fertilized eggs outside the womb. So it's not determining what is a human being or when life begins. Does this legislature, because they created this statute of wrongful death out of whole cloth, did this legislature, are these frozen embryos, these in vitro embryos, are they included within the definition of a minor child under the Wrongful Death Act? And on the Uniform Parentage Act, at Section 2617-707, it begins with this phrase: if a spouse dies before placement of egg, sperm, or embryo, the deceased spouse is not a parent of the resulting child. So again, if a spouse dies before placement of the embryo, the deceased spouse is not a parent of the child. So if that's Alabama's default position, that neither spouse is considered a parent until the embryo is placed in utero, then how can that same embryo be considered a minor child before it is placed in utero? I just do not think that we can overlook the distinctions between these permanently cryopreserved embryos that may never become in utero, may never become viable, may never stay anywhere but other than that state of perpetuity. That's a big distinction between in utero, and I think that's what the legislature was trying to define, that known scientific womb of in utero.
But you do understand, my concern here, the position that we find ourselves in is that when I look at this, and my natural inclination when I see that definition, person is a human being, comma, including, that sounds to me like they're defining a person as a human being, and they're saying comma, and that will include this non-viable unborn fetus, because that's our target in this legislation. Now, that could very easily leave open the universe of whatever else, is out there. And so for me to get past that construction there, I have to assume that the unborn are not human beings. If you look at this from a purely analytical standpoint, to get to your position, at least unless you can get me off of how that rule of construction works, it leads me down the path that I have to say that the unborn are not human beings, and therefore when the legislature came in, it came in and defined this as a human being, and then defined human being as a non-viable fetus in utero. That may be confusing to you. Trust me, it's confusing to me. And I'll stand corrected by my colleagues or by attorneys here. I'll stand corrected.
What?
But I will get you back to the point that the only way I understand what the legislature is doing is what they tell me. I don't care what Senator Chambliss said on the floor. There are many, many legislators in that body. All I know is what they put down and what they vote on and what they pass and what they write and what they give me, and that is where I am right now, is on that language in the Homicide Act and what the legislature thought it was doing. Did it mess up? Did it word it wrong? You know, we don't rewrite statutes. We already, by this very argument, we've already jumped over the hurdle of there's an ambiguity. So now we're into construction. And because this court on several occasions previously has zeroed in on the Homicide Act, my interest is the Homicide Act. I know we've got a lot of other statutes in the abortion context and everywhere else. My interest is the Homicide Act. So I hope that Mr. Wurtz will help me with that as well. But at least, I don't know about my colleagues, but as far as I'm concerned, we need to get to the bottom of what the legislature is doing with person is defined as a human being, comma, including a non-viable fetus in utero. Are they telling me that that is the only thing that they're recognizing, or are they just giving me an example of what a human being would be, and therefore the universe of human beings is a person? And that takes us down to the question of, well, is an embryo in vitro a human being? Is it a being in existence? Is essentially what the definition is, a being in existence. Is that what it is? So I apologize, but that's at least my mindset at this point.
Sure. And I guess if we go down your path on the including that's, again, my suggestion would be after we get to that point, if you're going into statutory construction, we have this known term in vitro. They could have easily extended that protection well outside the womb with two words in vitro. It's a known scientific unique term. So I guess if we're going down that path, and then if we look to the other statutes, I do think, as Chief Justice Parker said, we also try to interpret the statute harmoniously with other statutes that address related subjects. And we've talked about how the Human Life Protection Act, a sweeping anti-abortion, one of the boldest in the country, in furtherance of this constitutional amendment, which supports the sanctity of unborn life and the rights of unborn children, yet that statute treats and excludes from protection embryos, fertilized eggs, outside the womb.
Well, I have difficulty following your argument because that act that you're referring to, and we've had some quoting of statements by an author or a drafter, that it doesn't refer to in vitro fertilization or in vitro embryos. But that is a statute dealing with abortion, which is the termination of a pregnancy. And so by definition, a transferred embryo, there's no pregnancies. I don't understand the application of that act to what we have before us today.
The application is the definition of an ectopic pregnancy. Do we have a fertilized egg, fertilized embryo, which is, if life begins at conception, we have that fertilized egg, and it's an ectopic pregnancy, meaning it's implanted outside the uterus, then the anti-abortion statute says that there is no criminal penalty for that. So it is outside, it is not just exclusively in utero, it excludes from that implanted eggs which are outside the uterus, which would be in the same classification as these frozen embryos.
Well, going back to the language that Justice Shaw was asking you about, we have adopted a standard of statutory interpretation that we put forth in the case of Bond Harbor versus United Bank back in 2010 that says the word including is not a word of limitation. Rather, it is a word of enlargement. Now, you haven't asked us to overturn that standard. Sounds to me like you're just trying to talk around it.
No, sir, I'm not trying to talk around it, with all due respect. I'm saying if we look at the history of what was going on and surrounding that act with this debate of reviability, pre-viability, the legislature is just very clearly saying we are defining in utero. That's protected. That womb is protected. Anything outside that is not. And I think that's a very simple and straightforward reading of it without engaging in statutory construction. But if we want to engage in statutory construction, we presented you with the examples where the Alabama, despite this strong pronouncement in the sanctity of life, has excluded from protection fertilized eggs outside the womb. So,
well, Mr. Hines, thank you. We gave you even more time than your colleagues did. Madam Clerk.
Chief, he used all but 1.5 minutes of his full 30 plus the extra 6.5. How would you like me to divide the remaining time?
Well, they already had their time division established. Let's maintain that and give the overflow time back to the appellates. Mr. Mulheron?
Thank you. May it please the court. In addition to dismissing the plaintiff's statutory wrongful death claims in this case, the trial court also dismissed the individual plaintiff's common law wrongful death claims. As this court's probably well aware, there is no common law tort claim for the wrongful taking of a life under Alabama law. There's only a statutory wrongful death claim. And for this reason, the trial court correctly dismissed the individual plaintiff's common law negligence claims for compensatory damages stemming from the loss of the in vitro embryos. I'd like to discuss that in a second in a little more detail, but I'm going to probably make a mistake here, get off target, and try to also address some questions, Justice Shaw, that you were asking, and then address a point, perhaps, if I can, Justice Mitchell, that you addressed. I'd like to start again back to the point that there is only a statutory wrongful death claim in Alabama. So the death of a minor statute, which gives the cause of death to an estate when a child's life is wrongfully taken, has been in existence for decades, a lot longer than I've been alive.
So is it your position that these were lives?
It is, Justice Cook. I think that the embryo is a life, but the issue today is whether an embryo is a child protected under the Wrongful Death of a Minor Act. Did the legislature extend that protection to an in vitro embryo?
That's an awfully narrow gap you're trying to navigate there. It's a life, but it's not protected by the wrongful death statute.
I think that's what the legislature did. Do
you think our legislature in 1872 was thinking about in vitro embryos?
I do not. I do not, Justice Cook. Or in 1993 necessarily, because I think that's where we need to go next, is the death of a minor statute existed before I was born in 1966. It was already in existence. It said what it said. It hasn't really changed. But in 1993, this court considered two cases, Gentry versus Gilmore and Lawler versus Tankersley. Two cases in which the baby, the life, died in utero because of alleged medical malpractice on the part of an OBGYN. And in both those cases, the trial court dismissed the wrongful death cases and ruled that there is no claim under the death of a minor statute.
Mr. Mulheron, that was during the age of Roe v. Wade, and the court specifically said that they made their ruling in light of Roe v. Wade and decisions in other jurisdictions. They did not engage in statutory interpretation.
In those cases, there was reference to viability.
Which is the point of Roe v. Wade.
Right. Yes, Chief Justice Parker. So that was in 1993. And so then our legislature came back in 2006 and changed the Criminal Homicide Act to say, or to provide, that a person now is the term when referring to the victim of a criminal homicide or assault means a human being, including an unborn child in utero at any stage of development, regardless of viability. So, after that, that was in 2006. After that, in 2011, this court addressed Mack v. Carmack. Same type case as Lawler versus Tankersley and Gentry versus Gilmore that we had in 93. But now, with the new statute, with the change to the Homicide Act, this court in Mack v. Carmack in 2011 ruled that that same baby in utero now has a wrongful death claim. And so it looked to this statute. And so that's the timeline we have. And it was in utero. And then, Justice Shaw, to get back to what you were asking, if I may, we were talking about, or you were asking about, okay, we have human being, and then you said including unborn child. But when we read what the statute says in full, it says, means a human being, including an unborn child in utero at any stage of development, regardless of viability. So there are more words to it. And I discussed Gentry and Lawler for the point that that's what the legislature was addressing. That in some criminal cases where individuals were killed, women were killed with babies in the uterus, and there was the feeling that we're powerless to charge the assailant with the death of the baby in utero.
Doesn't the Brody Act say it's passed in memory of a situation where a baby was killed at 8.5 months of pregnancy?
Yes, Justice Cook. And so that Brody Act then allows us and allowed this court in 2011 to do what it did in Mack versus Carmack, to undo the Tankersley and Gilmore holdings, and to say we're no longer going to look and engage in all this science about whether the fetus was viable. It's if the OBGYN takes any alleged action that wrongfully terminates or extinguishes the life at any stage, there's a claim. And so, and my whole point is that this was passed to address the criminal situation, but we also then, in Mack versus Carmack, saw that we've always looked, with the Wrongful Death of a Minor Act. In 1993, we looked at what the Homicide Act said, and it was more restrictive. It was viability. And so we did not give the fetus a wrongful death claim. But then after this definition was changed in the Homicide Act in 2011 in the Mack versus Carmack opinion, we looked at it and did give the fetus a cause of action. And that's the point I'm trying to make. I don't think I'm making it well, is that to do that, the legislature amended the statute, as this court said in Mack versus Carmack, to include. That's what this court said in 2011 that the legislature did. Amended the Homicide Act to include a human being, including an unborn child in utero at any stage of development, regardless of viability. So in Mack versus Carmack, when this court looked at this statute to then give the non-viable fetus a cause of action for wrongful death, this court said, okay, what the legislature did was amend the Homicide Act now to include a fetus in utero at any stage of viability. So that's significant. And that then gets us back to what the trial court looked at in this case. The trial court literally held in her hands 2 code books, Section 6, Title 6, Title 13, and then held this court's opinion in Mack versus Carmack. And the trial court said, I'm going to follow the roadmap that this court gave us in 2011 in deciding whether that first cause of action contains a cognizable claim under Alabama law.
Mr. Mulheron, your time has expired, but we have another question up here on the bench.
I can honestly tell you and Mr. Hines, I have not made up my mind in this case. I'm merely searching for information, searching for a logical way to navigate through all this. If we were to rule in your favor, would it be accurate to say that the Alabama legislature, as a matter of public policy, has taken the position that 10 seconds before an in vitro procedure, 10 seconds before that embryo is inserted into a woman's uterus, it has zero protection as a human being. But once implanted in the woman, it has all the protections of the law and could be a victim of a homicide. So what I'm asking is that would be a public policy determination by the legislature?
Yes, I think that's right. Justice Shaw.
Let me ask a question, because I previewed this when the other side was up. I'm deeply troubled about dismissing at the pleading stage a case for lack of damages. And I understand your argument here that, well, it's a life, so you can't recover anything for a life. If we said, well, we can't make that determination of whether it's a life or not, we have black roads, but we're not beyond that. So how do I not send this? How do we not send this case back if it's a 12B6 on damages? Isn't the Rayleigh case right on point? I mean, y'all didn't respond to that case.
Well, Justice Cook, you asked, how do we send it back? The Burdick-Ison case is still pending in the Circuit Court of Mobile County. And the Burdick-Ison case is still pending with
the contract claim.
With the contract and bailment, which can be pled in tort or contract. It's sort of a strange
But that's not a claim against the infirmary. That's only a claim
That's
against
not,
the
that's a
center.
claim against my client, and
Yeah.
so it's still pending, and I think that's where we get to the Section 13 argument of the Constitution, where we say, well, Section 13 of the Alabama Constitution affords an individual to a remedy for his or her injuries, but significantly, in 2007, in the Poff versus Merit Energy Company case, this court specifically held there is no constitutional guarantee to a tort remedy or to a particular type of damages. And that's what this case, that's what this appeal is all about. The plaintiffs don't want a bailment claim or a breach of contract claim. They want a wrongful death claim with punitive damages. And that's what this court addressed in the Poff versus Merit Energy Company and said, no, there's no constitutional guarantee to a specific tort remedy.
Well, I mean, there is a negligence claim here. You know, I think it's fair to say that there was probably a breach of the duty. I'm not making a conclusion here. Probably a breach of the duty here. And the dismissal is either there are no damages at all, right? I mean, that's the reason for the dismissal here of the common law claims, because there were no damages at all. That's what the judge held, right?
I don't think that's right, Justice Cook. The trial court dismissed the second cause of action in both complaints because the trial court determined that the plaintiffs were making a claim for wrongful death in that cause of action. In essence, in listening to their presentations, they say that we've lost the value of the embryonic lives. We've lost baby Isene. And so that...
It's something, right? I mean...
Well, yes, but what the trial court said with respect to the second cause of action is, wait, you've either got a statutory wrongful death claim or you don't have a wrongful death claim, because there is no wrongful death claim at common law. And so if Austin... I go out here and I get run over by a student looking at his or her phone. My estate can file a wrongful death claim, but my wife, under Alabama law, cannot maintain a negligence claim, common law negligence claim, against the driver for the loss of the value of my life.
But here,
Or
the woman
emotional distress.
has had to go through a painful procedure to have these eggs harvested, right? And it's cost lots of money to go through that procedure. Is it more than $10,000 a pop, isn't it? And
Don't know the cost,
and
but
so
it's
you're
not
saying
cheap.
they get nothing for that, right?
That's not what I'm saying, Justice Cook. And more importantly, that's not what the trial court said. The trial court simply, once the Rule 12b motion was filed, the trial court simply went through a very methodical step, a very methodical process, and asked, is there a wrongful death claim under the Death of a Minor Act? The trial court ruled no. Then the trial court looked at the second claim and asked, okay, is there a common law tort claim under Alabama law for the wrongful taking of a life? And the answer to that is no. And so that then eliminated those two causes of action. But the trial court did not dismiss the alternative claims made by the Burdick Isenes. The Fondy Lepage plaintiffs did not make those alternative claims. The Burdick Isenes did, and the trial court left those in place, and that case is still pending. And then that goes back, I think, again, to this court's Poffenbarger case, which just says that, look, there's no guarantee of a right to a tort. And so are we today going to say, well, wait, there is? And we may.
Oh no, I'm not saying
Okay.
that. I'm just there is a negligence claim in Alabama, so
There is a negligence claim, just not in this situation. There's no negligence claim for the wrongful taking of a, well, it's statutory, and then you can prove the negligence to get the statutory recovery. But you cannot, as I said, my wife can't sue just for straight negligence and then claim, I want to be compensated for the loss of Austin's life, and I want to get my emotional distress damages that I've suffered due to the loss of his life. You just have the wrongful death claim, and this court has said life's of unlimited value, so you get punitive damages, not any other.
Mr. Mulheron, we have allowed you to go beyond your time. Justice Cook, are you finished for that question?
I am, thank you.
Okay, well, thank you, Mr. Mulheron.
Thank you.
And so next is Mr. Keene.
Mr. Justice Parker, Associate Justices, may it please the court. I'm Tommy Keene, and I'm happy to be here on behalf of the Medical Association of the State of Alabama. I first want to say, on behalf of the association, thank you for letting us express our opinion about this matter. It is our opinion that the effort to classify these extrauterine embryo as persons under the wrongful death statute should be rejected.
Mr. Keene, way back in 1916, an Alabama Court of Appeals quoted a Medical Association of Alabama publication and held that life begins at conception. Has the Medical Association changed its definition of when life begins?
No, but I think this method of creating life has been a change since 1916. It has been going on for some 40 years, and it has had great advantages to afford persons the ability to become biological parents, to bring new life into the world, and also to, importantly, assist people, mothers, expectant mothers, who are being treated for conditions such as cancer. It allows them to time pregnancies and still be biological parents after receiving chemotherapy, surgeries to address dysfunctions that they may incur. This process has been brought about long after 1916, and I say this, we can talk about conception, but you have yourself made this point. I think it's a very good one. There can be no abortion when there's no pregnancy, and an extrauterine embryo is not a pregnancy. It doesn't become one until implanted, and it doesn't even become one then until a placenta is formed, and then life starts evolving.
Mr.
And that's
Keene,
what
how has the practice changed since the Dobbs decision overruled Roe v. Wade? Prior to that, multiple embryos were implanted, and then they were selectively reduced.
No, not after implantation. Before implantation, they were reduced. And it's inherent in the process, Justice Parker, that there are going to be excessive embryo. Mm-hmm. Because to protect the mother and put her on through only one procedure to harvest her eggs, she has to be under anesthesia, conscious sedation, or general anesthesia. To protect her, we harvest as many eggs as possible. We create more embryo than are ever going to be needed. So inherent in the process are going to be excessive embryo. And in this process, all participants have known from the beginning that these embryo are not going to be treated as human beings or persons, the two terms I've been hearing all day today, because they enter an agreement. And they say when there are excessive embryos, they can be transferred, they can be donated for medical research, they can be discarded. That is not the treatment of a person.
They can be donated to other families as well.
Yes, donated to other families, correct, hoping to create another pregnancy. So that is not the treatment of a person. I think that is the real crux here. Before implantation, the embryos have a value. There's no doubt about that. I'm not here to address that question, Justice Cook. I think you've posed a good one. But prior to implantation, prior to pregnancy. We don't have a human being. We don't have a beating heart. We don't have any form of a human being. We have an embryo. It's a cellular structure.
Well, one of the contracts refers to them as human embryos.
They are human embryos, but they're not human beings. They're not persons. They don't have a beating heart. They don't have limbs. They don't have eyes, ears, and noses.
So
They begin the process.
What are they, Mr. King?
What are they?
Yeah.
They're embryo. They're embryo that are harvested to become implanted and hopefully begin a pregnancy. If the pregnancy takes, if the implantation works, then a pregnancy begins and a human being is formed. My time is up. I thank you for yours.
Thank you. And before Mr. Wirtis comes back to the rostrum, how much extra time does he get?
Close to 20 extra minutes.
Oh.
I hear you. Plaintiffs are on record. This is a motion to dismiss that's under review. We have moved to strike the contract documents, but curiously, in light of the questions and some of the comments and concessions, listen to this language in the contract with the Fondies. At Clerk's Record 75, page 17 of the Informed Consent for Assisted Reproduction. The technique of in vitro fertilization involves the creation of human embryos outside the body. Now, how can you take the position in litigation that they're pre-embryos and then get the parties to sign a document characterizing them as human embryos? And at the same time, this agreement at Clerk's Record 69, page 11, uses the phrase death of the embryo as one of the risks associated with assisted reproductive technology. What is the opposite of death? It's life. So they must be alive to die according to the documents that they got our clients to sign. This is not appropriate at the motion to dismiss stage. We were prohibited from conducting discovery. We could have expert testimony that we could offer the court with these troubling, difficult questions. So as a threshold matter, we renew our motion to strike. We ask the court to disregard, we move Ori Tennis to strike and disregard the comments construing the contract documents. They're just not appropriate before the court at this time. Justice Mitchell, you wrote a terrific law review article, Textualism in Alabama. And the point I was trying to make in my opening comments, we have all these statutes on the books, and they are to be read in pari materia. They don't have to be identical. They don't have to be associated with identical subject matter. The quotation from your law review article uses this phrase. Whoops. The principle of in pari materia does not require that the statutes being analyzed share an identical subject matter. To the contrary, this court has indicated that the subject matter of the statutes being analyzed need only be related, similar, or same generally. And you're quoting Ex parte Terex. So my point of bringing up the related statutes earlier, we have two statutes defining unborn child as from the moment of fertilization, the moment of conception. And the court need look no further after what you decided in Ex parte Ancrum with the assistance of a dictionary to conclude, to construct child in 65391 as the beginning of life, conception, fertilization. And you're within the bounds of statutory construction. Next point, the canon, the including canon. Bear with me for a moment. Justice Mitchell, your law review article discusses a number of canons in an appendix. One of the ones we cited in the blue brief was the presumption of non-exclusive include canon. Chief Justice Parker, you talked about it when you were examining Mr. Keene. The word including is not to be regarded as limitational or restrictive, but merely as a particular specification of something to be included or to constitute a part of some other thing. So with reference to the 2006 amendment to the Brody Act, Justice Shaw, we can't look at that amendment without the historical understanding we were living in the era of Roe v. Wade and Casey versus Planned Parenthood. And so our legislature was reacting to the command from the federal government. In that historical context, there could be no protection other. We could not do something with first trimester fetuses or before that embryos. So they wouldn't have been taking that up because of the command from the U.S. Supreme Court in Roe. It just wasn't an issue that was appropriate for legislative consideration in Alabama or anywhere. Same thing, the suggestion that the babies are disposable or embryos can be discarded. Again, Dobbs was decided in December of last year, and for the first time, this state was given the freedom, it was unbridled to determine what to do with unborn life. And so it's a case of first impression. We understand there are challenging issues, but this is the first court with this opportunity.
Mr. Wardis, let me ask you, if you win today, could the state appoint a guardian ad litem to protect the interest of your client's remaining embryos?
Always. Guardian ad litem statute is available to protect children in need, adults in need, certainly. But again, in the context of a motion to dismiss, we think principally the Wrongful Death Act of a minor should be construed to afford the remedy here. We haven't yet talked about our second cause of action. Our second cause of action is a general negligence cause of action claiming property loss. And under Rule 8...
And I don't mean to interrupt you because I want you to go there. You can see that I want you to go there. But
yes.
If we agree with your construction of the Brody Act,
yes,
then the destructions of the embryos would be a homicide, wouldn't it?
Not necessarily. Because they quoted in a reply brief for the first time an Attorney General opinion from Tennessee. And the Attorney General of Tennessee has determined with a Human Life Protection Act similar to Alabama's that the only way you get to homicide is if the embryo is implanted and there is a pregnancy with gestation. That's the only way you can invoke the statute. And so...
But you're running the wrongful death statute through the Brody Act, which is the Homicide Act.
You are running the Wrongful Death Act through the Brody. I say it's just one consideration of many, including learned treatises, where we have developed in science, the other cases from this court, including Hamilton, which has already decided this issue, any unborn child.
I'm going to go back and reread Hamilton. I didn't get that, but I'll definitely appreciate the rereading that.
We don't go through Brody exclusively, and I understand Justice Shaw's focus on Brody. That's what you used and invoked in Carmack, but the law has now changed.
But if we construed the Brody Act to be the deciding factor here,
yes, sir,
then the destructions of the embryo would be a homicide.
I disagree. Because there has to be implantation and there has to be pregnancy. If you follow the reasoning, and again, it's in their reply brief, we didn't respond to it, we didn't have an opportunity to. But Tennessee, if we in Alabama were to construe it that same way, it would have to be a pregnancy and a homicide through a gestational period, not an embryo before implantation.
I'm not following that logic, but that's all right. I wanted you to get to your other report, the common law claims, because I'm very interested in those. So,
the common law recognized the tort of sepulcher. We hadn't talked about that today, but it's been around since the 1850s.
Repeat that again, the tort of...
S-E-P-U-L-C-H-E-R. I'll cite Your Honor case. Wadley versus St. Vincent's Hospital is where Jefferson County Circuit Judge Bob Vance did a very good job outlining the law in this area. And for any of the law clerks or staff attorneys, the citation is 2006 WL 206-1785.
206-1785.
1785.
And one more time, the name of the tort is?
Sepulcher. And here is a quote from Devers versus Southern Express Company, Alabama, 1917. Whatever the law of England once was, it is now well settled in the law of this state that there is at least a quasi-legal right in, to, or concerning dead bodies, which the courts will recognize and protect by proper action. In an action of trespass, quaere clausum fregit, to recover damages for the unlawful disturbance of the body of a child, our Supreme Court has held that the parent can recover damages for injury to the feelings occasioned thereby. So, it's a common law tort. It's protected by Section 13. It existed at the time the Constitution was ratified in 1901 and again in 2022. We have the right at the pleading stage to proceed, and if after discovery we've got damages that justify proceeding on that theory, we should be able to do so. Again, we're at a motion to dismiss stage. I can't cite the court a case where a motion to dismiss was granted on a damages theory and upheld by this court.
I can't either. I agree with you.
So the appropriate remedy as a threshold matter would be to send us back, develop the record, if the court's inclined for us to do that.
Mr. Wirtz, what's wrong with the appellee's argument that the definition in the Brody Act was intended as a limitation? What's wrong with that argument? Is it an absurd argument?
I don't know that I would use the pejorative absurd. I think it may be an illogical argument, because if we adhere, as this court traditionally has, to the canon of construction about the use of the word including, then you must treat that phrase just as a representative example of types of humans that can be victims of homicides, but not to the exclusion of other types of humans, like the human beings that their documents characterize these embryos as.
So do you think, if that's true, what you're left with is a person is a human being? So what was the legislature trying to say there? If they're giving an example of a subset, they obviously envision something more than the non-viable fetus in utero, so they say a person is a human being. What were they trying to accomplish there?
And we can't resort to legislative history. Again, the rule is we don't consider what individual legislators may have thought or committees of the legislature may have professed. But historically, we know that this state has never reacted well to the limitations imposed by Roe v. Wade. And my suggestion to this court is, if anything, you might infer the legislature in the amendment to the Brody Act was saying, we don't care what you say about Roe, we're going to do it our way. And that's why we have the language that's so expansive.
What if I apply that canon of judicial construction that you're talking about and look at it and say, well, okay, it's only an example. What do I do from that point on? Do you have a suggestion if there's still a troubling question as to what does it mean a person is a human being? Do we still have an ambiguity there that I have to now go forward and try to figure out, was the legislature, did they use, perhaps inartfully maybe, were they trying to zero in and make an exception in that one situation, a non-viable in utero fetus. They're trying to point out, we're making an exception now. That is now a person. That is now, we'll recognize that as a human being, and that is now a person for purposes of protection. In other words, does that one canon of judicial construction end it all, even if I don't understand what the legislature is trying to accomplish there?
You know, I don't think it necessarily ends it all or answers all the questions. But I think in some of Chief Justice Parker's separate writings, in which you've concurred, Justice Wise has concurred, you have to look at other things, like the evolution of the science and the history of embryology, and even the developments in the past 10 years. And the contracts that were signed here were 2014, 2017, and the law has now changed with Dobbs. So all of this is unfolding and is evolutionary. I don't pretend to stand before the court and suggest when life begins. I'm not that smart. I'm here taking the cases that are on our books, the reported comments, as much study as we've been able to put into our preparation and presentation today to argue precedent requires, especially in light of the state constitutional amendment, that the people of Alabama have decided for us, this is what we're going to do in Alabama. And if the legislature has a problem with that, they take it up next term. But based on what we know, what the precedents are, what the canons are, what the existing statutes are, to me, the outcome's predetermined. I'll quit. I've got more, but I'll quit.
I have a hypothetical.
Yes.
Here. If we take your colleagues on the other side position that the threshold is in utero, with the advancements in science, if a pregnancy, if there are complications with a pregnancy, and the embryo is taken outside of the uterus for some type of medical surgery to save the life of that child pre-birth, is that child no longer protected?
Under their scenario, yes. If it's not an active pregnancy, you know, there are limitations to that. And I think the best way to do it, again, is summary judgment stage. There are a parade of horribles that both sides could throw out there with no evidentiary development, no expertise from experts. We could have brought an embryologist to the court. We could have brought a legal scholar to the court, trying to bring all of these authorities together in one cohesive package. We're at the motion to dismiss stage. All we did was allege a cause of action under the wrongful death of a minor statute. We alleged in the alternative a property damage claim. We ordinarily are permitted under Rule 8 to make those generic allegations, and then in the course of discovery ferret out the issues, and the court takes it up at the summary judgment stage or the JML stage. But I agree with you. At present, based on their argument, there's no protection. One last point. Justice Cook, you talked about the damages. It's a wrongful death case. You put on your best evidence. The jury is charged under Pattern Jury Instruction 1128, and then they decide what's necessary. It's not about valuing the embryo in the wrongful death context. Let's not lose sight of the focus in Mack v. Carmack. The issue is duty, breach, proximate cause, damages. What was the conduct? And under our wrongful death remedy, we're focused on the conduct. What duty was breached? How reprehensible was the conduct? And how much is necessary to punish and deter? And if it's too much, we have the Hammond-Greenall 61123 procedures to ensure there's not too much punishment.
Well, if we decide the case under the common law claims, the negligence and the wantonness, then the trial judge, if we agreed with you and sent it back on those claims, the trial judge would have to figure out how to charge the jury, because they couldn't use the pattern jury instructions for wrongful death. Now, I'm not trying to prejudge it here. I'm just trying to understand what the possible damages are under negligence or wantonness claim.
Well, we have help there too in precedent. The George Lanier Memorial Hospital versus Andrews case, 901 Southern 2nd, 714. Justice Harwood wrote this opinion. This, you may remember the facts. It was a 12-year-old child who went to a hospital. He had a reaction and died at the hospital, and they harvested his corneas without permission from the parents. So the issue there was whether, with the mishandling of the deceased child's remains, was there a claim for emotional distress damages? Justice Harwood, writing for the court, it is well settled that a plaintiff may recover compensatory damages for mental anguish, even when mental anguish is the only injury visited upon the plaintiff. Now, that's at Head Notes 15 through 19. There are 9 cases cited in Westlaw's key site for that proposition of law. Once plaintiff has presented some evidence of mental anguish, the question whether he should recover such mental anguish, and if so, how much, is a question reserved for the jury. So, it's simple. It's a property damage claim. We use common law principles for the damages, and the jury decides. If it's excessive, if not supported by substantial evidence, there are remedies for that. But we don't decide that at the motion to dismiss stage.
So I want to go over to the Brody Act issue one more time. I got one more follow-up question.
You know, I already volunteered to sit down.
I know you did. And my colleagues are going to get mad at me for asking one more question. The phrase "in utero," do you agree with me that that means in the uterus?
Yes, pregnancy, gestation.
That's it.
Thank you, Your Honors.
Thank you, Mr. Huertas. And we thank all the council. And a word for the students in the audience. You heard probing questions from the bench as we're dealing with this unique issue. We're trying to find out what we're going to do with it based on the law and precedent. So this was not just dry arguments. This was something to help the bench. And we thank you for enduring with us through all this process. So with that, we will take the case under advisement. The court itself will get together and talk about it immediately after this before we join the rest of you for lunch. So with that, we stand adjourned.
All rise. Court is now adjourned.